'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Might be coming down for sure.
Now, a question that you might have is what happens if there's a representation made that one party says something that induces the party to go enter into the contract, but through these rules around terms, for instance, the parole evidence rule, we find that it isn't a term of the contract. Is that the end of it? Because that might seem a bit unfair depending upon what the person said. No, it isn't. And there's a few other topics that I'd like to introduce you to, give you an idea about so that you get some understanding of them and that you're familiar with them. And they might help you flesh out this area about how the law works for when we're doing deals. Okay, let's hop in. There's many other options that are available if a representation isn't a term of the contract. We're going to deal with two of these as well as just briefly introduce the idea of implied terms, because that can cover some situations as well. But we're going to deal with a breach of collateral contract and misrepresentation. We won't deal with Australian consumer law, but there's a very important provision about misleading and deceptive conduct that will cover a lot of the situations that might seem unfair. So I just want to make you aware of that. So one of the options that is available under contract law is a breach of collateral contract. So while we might not be able to get a statement actually into the main contract, we can actually make a case that there is a separate contract, a collateral contract, that's been breached. So a collateral contract is a secondary contract. So this statement, right, from person A, so person B and person A makes the statement, but the statement can't get into the contract and B wants to rely on that statement. So that statement, it forms the basis of a collateral contract where A's promise that the statement is true is their consideration and B's consideration is entering into the main contract. Okay. In that case, we have a collateral contract. The main problem from B's perspective with this approach, because you might say, well, then why do we do all that about terms if you can just say sue for a breach of collateral contract? Well, the main problem is B might want to get out of the main contract, and there's only been a breach of this collateral contract, so they can't do that. Okay. So hopefully that makes sense. All that B can get here is damages, and they are bound by the main contract if we invoke a collateral contract situation. Another area that you need to be aware of is a misrepresentation. Now, this is quite a difficult area because it only relates to statements of fact. So it doesn't relate to statements of opinions or promises or anything like that, right? It has to be a statement of fact. So in Dick Bentley Productions, it was a statement of fact about the engine wear, right? So that's a statement of fact. Okay, that's a statement of fact. So discerning a statement of fact from an opinion and a promise can be difficult in many situations. But if there is a statement of fact that's wrong, and that's used to induce the other party to enter the contract, then we may have misrepresentation. There are three kinds of misrepresentation. Fraudulent misrepresentation, where you knowingly make that false statement or recklessly make that false statement. Now, recklessness is a particular legal term and it means disregard. Look, often I think it's used when the courts can't prove that they knew, but they're pretty sure they know, right? And so the only way you could have made that statement is if you had a reckless disregard for the truth. So when you knowingly make a false statement, if that happens, if it's fraudulent misrepresentation, you can rescind the contract and get damages. Negligent misrepresentation, we're going to leave till Module 12, okay, where the statement maker is under a duty of care and carelessly makes a false statement. Here again, you can get rescission. Innocent misrepresentation is where the statement maker genuinely believed the statement of fact. In this case, the other party can rescind the contract, but no damages. Okay. So misrepresentation does give you a cause of action if it's a statement of fact. The actual remedy is going to vary whether it's fraudulent, negligent, or innocent. Now, we're not going to examine implied terms, but I just want to make sure that you're aware that the courts and statute insert terms into contracts under various circumstances. It's not easy to do, but it does happen, right? If the contract only makes sense in terms of these implied terms, or the terms are implied by the conduct of the parties, or the statute requires that those terms be inserted into the contract. So let's have a look at some implied terms. Courts can imply or read terms into a contract to give effect to the parties' intentions. They may be unspoken or unwritten, but they're inferred by various means. They can be inferred through trade or custom, previous dealings, business efficiency, or common sense. Statute or legislation sometimes inserts terms into the contract. Since statutes override common law, these terms have effect, even if the parties have not freely agreed to the provisions. See consumer law, for instance, as an example. I want to make it clear, though, that it doesn't mean it's easy to get a term implied into a contract. In fact, it needs to be obvious that the term should be. For a term to be implied, it must be reasonable and equitable, necessary for business efficacy, so obvious it goes without saying. You must be able to clearly express it, and it must not contradict any express terms. So it's quite difficult to get them in. There we have it. We've seen that we've got these statements that can either be a term of the contract or a representation. And even if they're a representation, we do have some options about what we can do if one of the parties is making false statements that induce the other. We can use misrepresentation, which may allow us to rescind the contract, but only for statements of fact. And we have collateral contracts as a solution as well, where there's a contract to enter the main contract, which is breached when that statement isn't used. They're two key remedies or causes of action that we have available to us if we can't get a statement into the contract because of how the law works around terms. We've got one final piece of major content to do, and that's a special kind of term, a disclaimer, in the next video.